Professor Deborah Deno received her PhD in criminology from Wharton School and her JD from the University of Pennsylvania. Some of her accomplishments include being a member of the United States Commission's Drug and Violence Task Force, being co-editor of the Encyclopedia of Crime and Justice, and she has also published many articles on topics such as criminal law, procedure, and death penalty. And some of her articles have been cited by Chief Justice Roberts in one of his plurality opinions. And currently, she is working on a book analyzing criminal intent and conduct. She is now a professor at the Fordham University School of Law. Professor Deno brings our series of speakers on law and criminology topics to a close. We have heard from recovering offenders, a state prosecutor, and now we hear from a legal expert whose scholarship and arguments have importantly influenced our ongoing debates about capital punishment. Like our other speakers, Professor Deno's unique insight helps us peel back the layers of our complex legal system and to understand with greater depth a set of issues that are commonly referenced in our society but poorly understood. Please join me in welcoming Professor Deborah Deno.
Thank you so much for the invitation. It's really a pleasure to be here. When I got an email from Dr. Bruce Peabody to come and give a talk here, I was thrilled. My cousin went to Fairleigh Dickinson University, and I've always gotten this incredibly idealistic image of the school, and I can already see that having spent a little bit of time on your campus. It's gorgeous. So with that, I'm going to be speaking about the death penalty today, as you were just told, specifically on lethal injection. This is a topic that I, unbelievably to me, have been writing about for 20 years now and have a lot of passion about. And part of my emphasis is on the fact that so much of lethal injection, which is this country's primary form of execution, has always been incredibly chaotic and has never been more chaotic than it is today. So my theme will be toward that particular kind of argument. In January 2008, the United States Supreme Court decided an opinion called Baze v. Rees, that I'm going to be spending some time talking about. The court took that opinion because the court was concerned about all the litigation throughout the country over the method of execution of lethal injection and all the problems that that method had been creating. It had created so many problems that there couldn't be any more executions, and the death penalty machinery, as they call it, was halted as a result of that. Nonetheless, by virtue of taking this case, the United States Supreme Court, in writing about it, started to reveal to the public things that I and many other people who had been involved in this litigation already knew, that over the decades, lethal injection had always been an incredibly problematic procedure, so much so that I and others have argued that it's been unconstitutional. So that what you were seeing or starting to see in 2008 was something that we had already known all along, that lethal injection's deficiencies were documented over the decades, but simply ignored by state legislatures, by the United States Supreme Court, by state courts, by federal courts, by the public, and by the Department of Corrections. So what I'm going to start doing in this talk is give you a history and a backdrop of how lethal injection basically got this way, a little bit of history of execution methods in this country, and then I'll move on and discuss the Baze case a little bit more specifically. I'll discuss some of the research that I've done on lethal injection and what's going on currently, because part of my argument is that not only, as I said, was there always chaos, but that chaos has been no more problem or ever more problematic today. It's worse than it ever has been. So let's look at the history of methods of execution in this country. Originally, the original method of execution in this country was hanging. Every state in the 1800s had hanging as a method of execution. But over the years, there started to be horrible problems with hanging. There were public executions where hangings were taking a long time. They were incredibly grisly. There were huge stadiums full of people watching public hangings. And after a while, the state of New York got concerned about this in particular because their feeling was, with all these gruesome hangings going on, that there was a concern they might have an end to the death penalty generally. So as a result of that, you see a movement in this country to the adoption of electrocution in 1890. But then in 1890, there were problems with electrocution that I'll be talking a little bit about. Problems in a number of states, particularly the state of Florida, where there were very gruesome executions with inmates burning to death, essentially, in an electric chair, and photos of inmates that were, again, having an impact on the death penalty, and a concern by state legislatures with all this gruesomeness going around that executions may halt entirely. With that, there was a movement to lethal gas in 1921 in this country, in the state of Nevada first, but that too had problems. Probably the worst and most instantly problematic method of execution was lethal gas, where people were dying very slowly. This was used by Department of Corrections, but it was a gas that was used in Nazi Germany. It was incredibly painful. People could actually look into a gas chamber and see an inmate slowly suffocating to death. And so that even though that's still legal in this country, that did inspire a movement on to lethal injection in 1977. So what we do have now are these 5 methods of execution, and you can see over the course of the century and decades past that time, a movement from one execution method to the next, all of which because these methods are so incredibly problematic. Now let me go back to how we even got electrocution. As I mentioned, in the early 1800s, the governor in New York started becoming very concerned about these horribly gruesome hangings in New York and everywhere else. So the governor of New York decided there must be a new method of execution in this country. We can't perpetuate hangings. They're just too problematic. So the governor of New York appointed 3 individuals in 1888 to come up with a new method of execution. And part of what those individuals did was look at every method of execution in the course of history. And they spent a year doing this, these 3 individuals. And in the course of doing this, they thought nothing in existence was really humane. So what they thought was, however, that it seemed that electrocution might be humane. Why? Because there had been actually accidental electrocutions of individuals who had died, and the feeling was that electrocution and electricity, if you had a strong enough current, that might successfully execute someone. So in 1888, even though that was still pretty controversial, the state of New York implemented electrocution as the first method of execution in this country. Now, that was pretty controversial at the time for a number of reasons. On the one hand, electrocution was considered more humane. As I mentioned, there were tests on all sorts of animals that would, if you read about them, would sort of break your heart, but in 1888 seemed to be suggest that tests on dogs and large mammals, if they could be electrocuted safely, perhaps so could humans. So that was the good news. On the other hand, there was a report in 1953 in England suggesting that they would never go with something like electrocution because they considered it to be incredibly cruel. And they also considered lethal injection to be cruel. So at the same time when the United States was coming up or trying to come up with more humane methods of execution, other countries weren't going that route and weren't going with electrocution. Indeed, internationally, there have been only 2 or 3 other countries that have ever electrocuted individuals. And in 1953, England reviewed electrocution and also lethal injection, and actually thought that hanging was the most humane of all those methods of execution. So what you do find is over the decades is attempts in the United States to still hang and electrocute people and execute by lethal gas. But nonetheless, even with all these attempts to be more humane, there were always problems with these methods and some form of inhumanity. In 1972, the United States Supreme Court, for entirely different reasons, had a moratorium in this country on the death penalty. You may have studied that in some of your courses. This is a case called Furman v. Georgia. One of my, those sort of little-known facts is it's the largest United States Supreme Court decision that's ever been written. But in that decision, the United States Supreme Court held that because the death penalty seemed to be so random, like a bolt of lightning deciding who was going to die or not, that the court said to states throughout the country, basically, why don't you go back and rewrite your statutes and make the death penalty more fair? So states did that, and they went back, they revised their statutes so they wouldn't be as problematic, that they wouldn't be as random. And in 1976, in Gregg v. Georgia, which again you may have studied in your classes, the state of Georgia came out with a new statute for the death penalty that the state said, or seemed to accept, was showing that death wouldn't be this kind of random element, that we would be executing the worst of the worst. In 1976, though, if we were going to start executions all over again, which this country was going to be doing, the big question was at that time, how are we going to be executing people? And it was a big question for a number of reasons. Number one, there was recognition that the methods of execution that had been used up to that point, hanging, electrocution, firing squad, and lethal gas, were all terribly problematic. We already knew at that point that electrocution had resulted in a number of very grisly kinds of executions, with people dying slowly, as I said, or their heads going on fire, or some indications that there was suffering. Lethal gas, as I had already mentioned, had been highly problematic. There was a concern in 1976 that some executions might be televised. There was a big movement at that time to televise executions, because some state legislatures were saying, look, if we're going to have a death penalty and have these kinds of executions, they should be televised to make sure that they're done humanely. So Ronald Reagan, then President Ronald Reagan, thought, along with a number of state legislatures, maybe the best way, Ronald Reagan said, would just be executing people like you would put an animal to sleep, and make it much more humane. At the same time, people thought it was going to be something that you could actually televise, and it would look good to witnesses or anybody viewing that. And lastly, it was probably going to be a lot less expensive, perhaps, to have lethal injection, because electric chairs were getting expensive, and et cetera, and lethal gas chambers were horribly expensive. So this was the beginning of a movement to try to see whether a new method of execution could play out. And the state of Oklahoma really took that suggestion, or that sort of implied suggestion, to the next level. In 1977, the state legislature, by virtue of recommendation of Senator Bill Wiseman, brought it up to the state legislature to try a new method of execution in that state. And the way this came up was by suggestion of the state's medical examiner. What had happened was a state legislature, as I said, Bill Wiseman, went to the state's medical examiner and said, look, let's try another method of execution. What do you think would be the most humane way of executing somebody? And Jay Chapman, who was the state's medical examiner and somebody I have interviewed countless times, recommended lethal injection. And then Bill Meisen said, well, how do you want to do this? So in the course of a couple of hours, they took out a yellow pad and jotted down a formula that Jay Chapman thought might work. And it's a formula that I'm going to describe shortly. But it's a formula of 3 drugs that would be administered sequentially to an inmate. And the first drug would be to make the inmate unconscious. The second drug would be a paralytic agent to hasten death, but also to make it so that that inmate was paralyzed and couldn't move. The reason being is Jay Chapman recognized early on, and he told me this in a phone conversation, that he realized that the first drug would only sedate the inmate, but that people could move around. It would be a pretty horrible thing for a witness to watch. But if they were paralyzed, witnesses would just see an inmate very still. So you would inject a paralytic agent. And then the third drug would be something called potassium chloride that would really be a very quick-killing drug. It's a very strong toxic. And actually, I've spoken to anesthesiologists who have actually injected themselves with it just to test it, and they said it's like a hot poker being put in your stomach. It's just incredibly painful. So this was the formula that Jay Chapman came up with. And it was the formula that eventually passed in the Oklahoma State Legislature, and there were debates about this. I tried to get the recording of the debate, but it wasn't available. Somebody apparently had taken it home in the 1970s, and they never returned it. So I was never able to actually listen to it, but I was able to read newspapers that were making quotes about it. So you have this huge debate in the Oklahoma legislature. And on the one hand, you have arguments saying, look, this is the most humane method of execution, much more humane than electrocution, which Oklahoma had had before. There were quotes saying with electrocution, I'm just quoting now, people's eyeballs pop out. Even if they wear a mask, they start bleeding, and their head goes on fire. It's a torturous process. So let's move to lethal injection. It's also much cheaper, the debates were saying among all these legislatures. But other state legislatures were very concerned about it. They said, nobody's ever used this. What happens if you inject someone with drugs and they don't die, they just go into a vegetative state? What are we going to do now? What are you going to do then? What if it's actually much more painful than we think it is? So there were debates to and fro, and actually Jay Chapman, the medical examiner, went to the debates and said, this is going to work. At the same time, several things became clear. Jay Chapman told the Oklahoma legislature that he still had concerns about the drugs. And Jay Chapman, bless his heart, is very open for being very pro-death penalty. He's very open to me in all the interviews about that. He told me he really actually never cared if people suffered, but at the same time, he was asked to come up with the most humane method of execution. But still, in May 1977, and I actually had to remind him of this because he didn't realize that he'd been quoted in the Oklahoma Daily. He had said that if the drugs aren't administered properly, the convict may not die and could be subjected to severe muscle pain. The major hazard of using lethal drugs, he said, was the execution of criminals is missing the vein in establishing an intravenous pathway for the drugs he was warning people about. He also told me privately and also said publicly to CNN that he always thought that doctors were going to be doing this, that it had to be done by a trained medical examiner. So he didn't realize later on, and was very surprised when I told him just a few years ago that actually sometimes people who had never been trained in using a syringe were actually the ones administering these drugs. So the state correctioner's director, Ned Benton, said that his office would work through the summer with medical examiner's office to find the best method of drug injection, which could be defended in court. But truly, who he was really working with was always just Jay Chapman. So if you get any sense that it was an office of a number of people, it was really just Jay Chapman. Benton said it was his understanding that state laws do not restrict who gives shots, and that's absolutely true. In other words, the state laws never said who is supposed to be giving this, and they didn't restrict it to medical doctors, and indeed, from my knowledge, there's never really been a medical doctor who has actually openly been appointed to give these injections. It's all been done undercover. And nobody's really known who's been doing this. So, but one thing that also became clear during this legislative debate that was quoted in the Daily Oklahoman with my interviews with people involved in this process was at the time, the state of Oklahoma never really thought they were going to execute anybody anytime soon. In fact, they thought that the death penalty might actually be abolished. So to them, this was all a theoretical process. Officials with the State Department of Corrections say it may be years, if ever, before they're required to carry out the mandates of the legislature. And they felt that when they were going to do that, that new and better drugs may be available. Again, they didn't think they would ever have to do this, but when they did, maybe decades down the line, that there would be new and better drugs. But in fact, that was never the case. This was always the drug formula that was created then and that is used to the present day, despite all these qualms about it. Today, lethal injection is used in 25 of the 33 death penalty states as the only method of execution. It's the method of execution that's used in all 33 states, but it's the only method of execution that's used in 25 states. There are 9 states where inmates have a choice of which method they want, or sometimes people make that choice for them. The word choice is a little bit of a misnomer, and in most cases inmates are pretty depressed about the whole prospect of dying, so they always say, oh, you choose. Very few inmates actually choose the way they want to die, so if this looks incredibly generous, it's really sort of in theory. 2 states have either lethal injection or hanging, which is legal to this very day, and there have been hangings as of just a few years ago. There's still 1 state where a few inmates can use firing squad. A couple of years ago, firing squad was no longer used in any state, but there's still inmates on death row in Utah who were grandfathered in, who could use the firing squad, and there was an firing squad execution as of a couple of years ago in the state of Utah. 4 states allow still for a choice between lethal injection or electrocution. So there can still be electrocutions in this country. And I testified a few years ago in a case involving electrocution in the state of Virginia that was challenging the constitutionality of electrocution, but nonetheless that was still declared to be constitutional. 2 states that still allow inmates a choice between lethal gas and lethal injection, and that's California and the state of Missouri. Of course, there are 17 states that no longer have the death penalty, and as you well know, one of those states is the state of New Jersey. What you may not well know is that the last issue of litigation in the state of New Jersey involving the death penalty, and the one that was sort of halted things entirely, was over the issue of lethal injection. And attorney Kevin Walsh and his group were very involved in that. But that was one of the main issues in New Jersey right before the state basically just got rid of the death penalty. So this was just so you know, lethal injection litigation was live and well in New Jersey as well. It was probably the straw that broke, it appears to be the straw that broke the camel's back, because it was the last major issue of litigation in New Jersey. Now you do see states, 39 states adopting lethal injection, and the way they did it, as I said, lethal injection was first created in Oklahoma in 1977. Literally 2 days later, Texas adopted lethal injection. Both Texas and Oklahoma were discussing lethal injection at basically the same time. The state legislatures were doing this. How this information got from one state to another, I wasn't sure. I interviewed a lot of people. Nobody really knew. But you do have these two states coming out with lethal injection in 1977. Then Idaho in 1978, New Mexico in 1979, and the state of Washington, and then Massachusetts in 1982. So in 1982, by 1982, you have 6 states stopping lethal injection. Ironically, even though the method had never even been used to execute anybody. And it was the first time the method was ever used was in 1982 in the state of Texas. So you have six states already adopting a method of execution between 1977 and 1982 that had never been used on any human being, never had been tested even on an animal. You had animals tested, unfortunately, for electrocution and even lethal gas, but no animal was tested for lethal injection. So the first animal to be executed by lethal injection was a human being by this three-drug process. As I'll bring out later, indeed, and that this was starting then, that the drugs that are used in lethal injection now have been banned for years by veterinarians. It would be illegal for them to use them on animals for purposes of euthanasia, but they're still legal and always have been to be used for human beings in this country. But just so you can see the rapidity in which lethal injection adopted and sort of the negligence in adopting for states a method that had never even been used yet. Was used first in 1982 and poorly used in 1982. The first lethal injection in the state of Texas did not go well. Nonetheless, states started adopting. This is a quote from Baze v. Rees. This is a little bit, I testified in the trial court decision of Baze v. Rees. It's a little case started in Kentucky, in Frankfort, Kentucky. So there were 12 experts testifying, but the judge in that case made this conclusion based on the conclusion I'm going to read now, based on 2 studies that I had done on lethal injection, as well as all my work on interviewing Chapman and just looking at the history of the start of this pretty awful method of execution. And that judge at the trial court level said, there's scant evidence that ensuing states' adoption of lethal injection was supported by any additional medical or scientific studies. Rather, the various states simply fell in line, relying solely on Oklahoma's protocol. So it was like a domino effect. Oklahoma adopts a method, 2 days later Texas does. As you can see, 6 states adopted before anybody was even lethal injected in this country, and a total of 39 states adopting a method despite a huge number of problems with that method over time. In the ensuing years over states, there were many problems with lethal injections, problems with injecting inmates, particularly many of these inmates are heavy drug users. Recognition, as there was recognition in the state of California in 2006, that half of the 13 inmates in that state, by virtue of autopsy evidence, weren't given sufficient sedative, in which case it was pretty clear that most of them were not sufficiently sedated by the time they were given the paralytic agent, and at which point they were injected and in torment by the third drug. The major argument at this point by lethal injection was the effects of the sedative, that there wouldn't be enough of that sedative given, and that the sedative would wear off, but then the inmate would be injected by a paralytic agent and paralyzed, and then injected by a hugely painful toxin. But the inmate would be so paralyzed, the inmate wouldn't be able to cry out in pain. And this is the testimony that many anesthesiologists were giving, and that autopsy evidence was revealing. There were also issues that were going on when who was doing this. In the state of California, for example, which has the largest death row population, it was clear, as I just said, that half of the people who had been executed in California weren't given enough of the sedative. And evidence suggests that they were paralyzed but in horrible pain when they were being injected by the other two drugs. There was also evidence, and I'll go into more detail on this, that the people doing the execution process hadn't a clue what they were doing. They were all in a room. It was a dark room to protect their identity, passing syringes one to another and not knowing who each other was, or even being able to see whether the syringe was properly filled. In many of these cases, in most states, an inmate would be in a separate lethal injection room, would be injected, but the people would leave the room and go in a separate place to administer the drugs. And there would be tubes connecting one room to the other, but the tubes would be leaking the drugs. There are photos that you can see of these tubes leaking. There were cases of inmates being injected in the neck, and indeed in the state of Kentucky, until the lower court opinion, which I testified in, inmates could be injected in the neck. Why? Because so many of these inmates are drug users. It's very hard to find a proper vein. They're injected in their fingers. They're injected in the groin area in what's called a cut-down procedure, where you cut around the groin to expose a vein, because it's so difficult getting veins in these inmates. In a couple of cases, the syringe was so poorly placed in an inmate that it would fall out and all the drugs would start leaking. So there were tremendous problems with who was doing this. Sometimes my surveys have shown they were prison volunteers, people who may or may not have even held a syringe in their life. All of a sudden doing a procedure that even a very sophisticated anesthesiologist would have trouble doing in this particular climate with an inmate who may be very young or very muscular, or a drug user who was, in other words, incredibly physiologically challenged. With all these problems, Chapman several years ago came out and made a very bold statement. This is someone who's for the death penalty, as I said, who has no problems if inmates suffer. Nonetheless, what horrified him most was not that inmates were suffering, but that the people doing this were doing such a bad job, because when he created this procedure, he didn't think the formula would be the way it was, and that doctors would be introducing this formula. He had no idea that inexperienced medical people would be doing it, or that lethal injection would be conducted in prisons without somebody being right near an inmate, he didn't think that people would be in a different room. Everything about how the procedure was being conducted amazed him. The mere incompetence amazed him. So he was coming out saying, maybe it's time to change the formula. If you're not going to have doctors, you really have to change what you're doing. At the same time, I and others were starting to be able to get more information on how lethal injection was conducted. There's always been litigation about lethal injection. It started in 1977. Many people don't know that lethal injection was immediately challenged as unconstitutional as soon as it evolved. Nonetheless, Department of Corrections were never forced to provide information on how they conducted lethal injection executions. So in 1977, they didn't have to reveal the drugs. They didn't have to reveal who was doing the lethal injection or where it was being conducted or who was doing it, etc. So who was coming up with this, the drugs or trying to perfect this formula? One of the people was Fred Lucher, who was at that point, up until the 70s, the primary creator of execution equipment in this country. In his basement, Fred Lucher was a graduate of Boston College. He said he was an engineer, but he really wasn't. He majored in history. But what he was doing in his basement was basically creating methods of execution. He would build electric chairs. He would build lethal and gas chambers, and he would also build lethal injection syringes and ways to inject people. Again, all in his basement. prison. And it's only prison personnel who really knew that. Earl Morris did a documentary depicting Fred Lutcher's execution business in a documentary called Dr. Death, and it was only that revealed a lot about him to the public in a way that other people didn't know. I had an opportunity to interview Fred Lutcher way before any documentary had been made about him, and he would describe to me how he would make this equipment, and it was pretty frightening that he was the major manufacturer of all this execution equipment. The only way he was drummed out of business was he was an anti-Holocaust person. He claimed that the Holocaust never existed, and it was by virtue of Jewish groups sort of exposing him that anybody even found out that he had this execution business and that he wasn't an engineer. And had that not happened, he would probably still be making execution equipment up to this very time. So these are the people who were sort of running this business. J. Chapman always said that, he was trained in, determining how people died, but not on how getting them that way. He himself admitted to me he wasn't the best person to have created this kind of formula. When I was researching all these problems, I wanted to know more about these drug protocols because so little was known. And I was writing more about this area. I had written about electrocution, and now I was writing about the constitutionality of lethal injection. Because a lot of people were saying, oh, lethal injection, let's go to that. That's constitutional, but the little I knew of it sounded really bad. In fact, I thought, this could be worse than electrocution, the way people are doing it, but I wanted to know more. So what I did was I conducted 2 studies, one in 2001 and one in 2005. And these were studies of every Department of Correction that had lethal injection at that time. So that was, at the time, 36 states. And I interviewed, and got as much information I could get as any state and talked to whoever would talk to me, to the Department of Correction of how they actually conducted their lethal injections. And in 2001, there wasn't that, even though there was a lot of litigation, it wasn't really making any headway at the time. Why? Because nobody really knew very much. And I was really astonished by what people were telling me. And this is why I ended up being an expert, or one of many reasons, in the state of Kentucky. Because when I called Kentucky, the person who spoke to me there said, oh, we do it all on a case-by-case basis. We get whoever's around and we get them together and we try to figure out what drugs we have available and how much we have and who's going to do it. Who's there that day to conduct the lethal execution. And it was clear it was very much off the cuff, and the person made no apologies for that. And I documented everything. But it wasn't just the state of Kentucky. I called around every state. I found in a disproportionate number of cases, the person conducting these executions were prison volunteers. That when they did reveal drug formulas to me, and there were only 7 states that would reveal the actual drug formula, the measurement, that the measurements were horribly off. In other words, it was very clear in a number of these states that they didn't begin to give the sufficient amount of sedative, in which case it was pretty clear that if that's what they were doing, that this inmate would be paralyzed and suffering from the 3rd drug. But this was the formula that they were giving, and they didn't even know how inadequate it was. Many states wouldn't even tell me their formula. They would say that it was 3 drugs, but they wouldn't tell me what it was. And they wouldn't even tell the attorneys what the drug formula was, attorneys who were getting ready to litigate. So I documented all of this. I found that the types of amounts of chemicals injected were horrifying in terms of what they were using and the amounts that they were using. Stunningly bad. That the training and qualifications of the lethal injection team was non-existent. This was typically a team of people, in some cases people who hadn't even held a syringe before. That if there was involvement of medical personnel, it was typically for a doctor just to declare somebody dead, or for a doctor to get involved underneath or furtively. We later found out that some doctors got involved because they couldn't stand knowing the extent of suffering that was going on with these inmates. So sometimes they would step in and give advice, even though, according to their professional dictates, they weren't supposed to be doing that. In the 4 years between my study 1 and study 2, I also found out that the secrecy grew. By the time 2005 came around, I had already published the results of the first study, and nobody really wanted to talk to me for the results of the second study. The cat had been out of the bag. In the 4 years between my study 1 and study 2, the number of states with complete protocols actually fell to less than 1/3 of study 1 numbers. So actually, during those 4 years, states became much more secretive because they were finding that they were vulnerable to litigation. The state of Kentucky had been vulnerable to litigation as a result of these surveys, and also the growing involvement of anesthesiologists and greater sophistication of these amazing death penalty attorneys who are really the best. These people who get involved in these kinds of cases are just stunningly good as attorneys, and they're really young. The attorney I worked in with Kentucky looked like he was about 12, but he was very good, and that's inspiration to all of you who want to be attorneys or go out and get involved in these cases. It's usually these very young attorneys who are making Supreme Court cases. That's inspirational, isn't it, to you? Also, the number of states claiming confidentiality about their protocols increased nearly fourfold. So the issue becomes, what are they hiding? And it was a very, very secretive process, and actually remains so. And so my argument is that since the Baze v. Rees case, that things are even worse than they ever have been. And so let me just give you some basic stats to hone that, and then save enough time for questions. Of course, as I said, this is how we're seeing lethal injection today in light of this history. Lethal injection is, of course, the primary method of execution in all states that currently have the death penalty, and it's applicable to, over 3,000 people on death row. The other methods of execution, as you can see, are still viable. There have been over 1,000 executions using lethal injection since the death penalty was reinstated in 1976. As I said, from the start, lethal injection injected controversy because of all these botched methods. These botched methods exist to the present day. It's like nothing ever changed. If you think it has, it hasn't. These problems eventually resulted in a de facto national moratorium on all execution methods, lethal injection executions from September 2007 to May 2008. And again, this was a halt created by the United States Supreme Court when they granted cert to lethal injection in the state of Kentucky. Now the result of the Supreme Court's case would impact on all states because their injection procedures were substantially similar to Kentucky's. So in other words, whatever J. Chapman came up with in 1977 on that little scribble pad in a couple of hours, that's what was used until 2008 in every state that was using lethal injection. So the question in Baze was, does Kentucky's lethal injection procedure constitute cruel and unusual punishment based on these three drugs, the three drugs that J. Chapman had originally recommended? And the sedative, sodium thiopental, this paralytic agent, and the potassium chloride, And the court eventually said yes, but it was a very, very splintered Supreme Court decision. Why? Because the petitioners haven't carried the burden of showing that the risk of pain from this method would be inhumane or unconstitutional, number one. And number two, the petitioners also hadn't shown that there would be any other kind of method that would be an improvement over what they had. But as I said, the court was really splintered. There were only three justices going with the majority opinion and 5 concurring opinions. And this is huge in a Supreme Court case. I mean, usually a strong case is going to be all the justices agreeing the same way. But only 3 justices did, and you had 5 very separate concurring opinions, and then 2 dissenting opinions. So it was really a weak case because of that. And Justice Stevens, who used Baze as a podium for saying that the death penalty should just end, and this is the reason why, said that because he assumed that the decision would bring the debate about lethal injection as a method of execution to a close. But he said it's clear that it's not, that there were going to be a lot of problems, and indeed there have been many problems. And there's been chaos after Baze. So much chaos that one of the worst lethal injection, these were the worst lethal injection execution ever, happened in 2009 after the Supreme Court's decision. This was the case of Romel Broom in Ohio in September 2005, and there's September 2009, and there's a documentary that's coming out, just came out on the Romel Broom. An execution team spent more than 2 hours unsuccessfully trying to obtain a vein for IV access despite Broom's attempts to help. Not only were they trying to execute him, but he was helping them, and they couldn't do it. After 18 needle pokes all over his body, in which he was crying throughout, and there's a videotape of him crying that has only been seen by a few individuals. They couldn't do it, and ultimately the execution was halted. And indeed, at one point, people were so exhausted trying to kill Broom over a 2-hour period that the execution team left the chamber just to take a rest and try to decide what to do. And during that 2-hour rest period, Broom himself grabbed a needle and tried to inject himself because he was in so much pain he just wanted to die. They wouldn't even let his attorney come in to be there, to be with him, or to console him. Ultimately, the execution was halted. They couldn't even execute him. That's never happened before with a lethal injection execution, but it did in 2009. Broom is now challenging other plans to execute him. Ohio wanted to execute him a week later, but that was challenged. Then, after all these problems, states started switching their protocols. For example, 2 states, Washington and Ohio, switched to a single drug protocol using just the sedative and not the more controversial paralytic agent. In 2010, Hospira, the sole manufacturer of this sedative, halted its production of the sedative entirely because it was being used in execution, even though the drug also had many legitimate uses in hospital settings. Sodium thiopental, the sedative that's used in lethal injection, used to be the primary sedative that was used when people went into surgery. If you've had surgery, you were probably put under by sodium thiopental. Now it's propofol, the Michael Jackson drug. But anyway, it was used in many, but it was only one company making it. And that company, when it was exposed, basically shut down its creation of sodium thiopental because it didn't want to be caught up in this lethal injection chaos. It was embarrassed. Hospira's decision led to an immediate shortage of sodium thiopental, causing prisons to purchase the drugs from other states or from international sources, a big one being Dream Pharmaceuticals, a company in England. There were pictures of that company. It's right behind a driving school. You go to your local driving school to learn how to drive, and right behind that is sort of this pretty shady-looking company that sells all sorts of drugs, and this is where the Department of Corrections were purchasing their drugs. Nebraska purchased sodium thiopental from India. Other states went to Austria, Germany, Pakistan, and elsewhere, causing international consternation because these countries don't have the death penalty, and they were horrified to learn that we were purchasing drugs from them. But also there was horror because these international sources aren't known and not approved by the Food and Drug Administration. Therefore, the drugs may be impure, expired, or unsafe, and thus ineffective for making inmates unconscious during an execution. If you're buying your drug from India and flying it over to this country, there's no assurance that it's being refrigerated or that it's even being treated properly or handled properly. Most recently, a number of states have switched to pentobarbital, a change that's currently being litigated because the drug's effects in this context aren't known. It's never been used to execute people. The sole manufacturer of pentobarbital has also opposed that drug's use in execution and has pressured companies to stop sales of it. And these examples are only a few of the rapidly expanding number of cases that currently exist in this in lethal injection litigation. Ironically, as of today, that's November 8th. Sorry, I meant to update that. That was my original date of talking. Kentucky's method of execution is still being debated, and most likely will go to a one-drug method. So I'm just going to end with showing what states are doing now, because there's been a scatter effect. You have a number of states, the orange states, that are using just the sodium thiopental. Some states are using pentobarbital. Some states are using both, one or the other, depending on what they have available in their cabinets that morning, so to speak. Some states are using propofol. You have some states, as I said, using both. Some states have one drug, some states with 3 drugs. Part of the chaos is that in December 8th of 2009, you have states using, the state of Ohio starts using just one drug. But then you have this scramble of states when Hospira officially exits the market. And what happens now is you have this huge, all these developments on almost a monthly, if not basis, on states scrambling to try to get these drugs, either from other states or from other kinds of countries. And so, and you've never seen anything this quick. Even with everything that was happening with lethal injection, historically, you never saw this speed of changes in protocols over a period of time. So Ohio does this, Washington does this. So just to get a sense of this, in 2011, you start seeing these rapid state changes in a way that you've never seen. From March 10th to May 3rd, 5 states in May changed their protocols, which is extraordinary. Not only compared to other methods of execution, but just lethal injection, the number of states trying to make changes in their protocols, either from changing to a different drug to changing to a different type of protocol, all going every which way and panicking as a result of this. 7 states changed between June and November in some way, all trying to, and all irresponsibly so, in trying to figure out what they're doing. In 2012, you had changes to lethal injection protocols, one right after another, with one state doing this, another state doing that. And so you can see through this diagram the extent of these kind of changes. We started with the 3-drug process that has always lasted till modern times, what Chapman came up with. Then you started seeing states going either with sodium thiopental or pentobarbital. And then you see the other states that are just changing depending on which drug they're using, then this kind of splinter effect that makes it so the Baze v. Rees decision makes no sense anymore, because states aren't even using the drugs or the formula that the Supreme Court was sort of advocating. In 2012, with this one-drug method, you start seeing some states using pentobarbital, sodium thiopental, or propofol in all these different ranges of ways. Again, this scattershot effect and complete chaos that has no precedent in the history of this country, either with death penalty or with lethal injection, or any method of execution. So I'm going to end with this, because you always know something garners the attention or means something when it garners the attention of Colbert, Stephen Colbert, who covered this complete issue in the Colbert Report, and everything you're going to hear in his report is actually accurate, except for his comment about the country of China. But everything else is totally true, and he just puts it together that I think makes a whoops, oh, that's right, I'm supposed to go back, makes a point. So let me
Folks, I don't have to tell you, the world is a very scary place. That's why some nights the report happens. Which brings me to the second installment of my long-running 100% televised series, Tiny Triumphs. Tonight's heartwarming news comes from the heart-stopping world of capital punishment. Recently, the state of California was all set to carry out its first execution in 5 years, when they discovered their supply of the lethal drug sodium thiopental had expired on October 1st. Evidently, the bottle had passed its kill-by date. It only got worse when they found out there was a nationwide shortage of sodium thiopental. I assume China bought it all to put in our toothpaste. After frantically looking through their cupboards and couch cushions and coming up empty, California had to look elsewhere.
California prison officials tried for 2 months to find the rare lethal drug they needed to carry out the state's first execution in 5 years. New documents show officials scoured the globe from Pakistan to London for the drug,
making it the first tour of Europe and Asia looking for drugs that did not find any. Now, as it turns out, England did have sodium thiopental, but the shipment was stopped at the border for inspection by the Food and Drug Administration, which is understandable. There are lives at stake here. If there's something wrong with that drug, somebody could not die. Luckily, just when it seemed like this story of state-sponsored execution wouldn't have a happy ending, California got help from right next door. Arizona agreed to lend California a cup of death. Nation, it's these kind of stories of neighbors helping neighbors that really fill your heart with joy. Or if you're on death row, 12 grams of sodium thiopental. I don't think that act of charity went unappreciated. California Department of Corrections Undersecretary Scott Kernan went out of his way to send a thank you email, writing, and I quote, "You guys in Arizona are lifesavers." So bravo, Arizona. You've proven that through teamwork, we can build a bridge together to the 21st century and then hang someone from it.
Yeah, I asked you, when watching the presentation, I was just kind of interested in knowing that, in your personal opinion, do you feel like any type of death penalty or the death penalty in general is a violation of human rights?
Well, I do. I can't go through why I feel that way, but all those, the results of this talk might suggest where I'm coming from on that particular issue.
Hi, first of all, I thank you for your presentation, and I really respect your scholarship. And since I'm a sociologist, not the legal scholar, this Colbert Report really sort of matches with my questions. For example, I'm sorry to be a little provocative about your presentation, but what if somebody finds very perfect scientific method to kill? Then would you say, well, that's fine? Or because I'm saying this, let me give you some background of my question. Number one, it seems to me that the legal and political history you mentioned try to really find humane way of killing people under the guise of scientific method, and somehow they figure this out, and the lethal injection is the way. But I cannot help but, coming away with the idea that this is only the political and legal agenda in disguise. No matter what, they're going to do this. 33 states you're talking about, even if you, present your case and made a testimony and it didn't change your mind. And your kind of presentation, even at the end, all these ingredients may be changed, but the big picture still doesn't change. So what can be our symbolic, legal, political authorities, implication which we don't see here?
Yeah, that's a wonderful question, and certainly one that I've thought a lot about. This is, when you challenge a method of execution, there's not a consensus in the death penalty community about this. When I first started writing about this topic, many death penalty attorneys didn't even want to get involved in challenging methods of execution for the very reason that you mentioned, because if states start perfecting a method of execution, then they can kill more successfully, and then there's not going to be a problem. And I have several responses to that. Number one, I feel extremely uncomfortable using as guinea pigs inmates who are going to be tortured through an execution process with the faint hope, and I want to emphasize faint hope, that if they're tortured enough, that people might start questioning the death penalty as a result of that and get rid of it in this country. I think that's a really egregious philosophy. My feeling has always been, if we're going to execute people in this country, if we're going to have a death penalty, that it should be humane. And that should be our foremost concern. Number two, I've never seen a situation until recently that litigation about these methods of execution results in getting rid of the death penalty. It's not going to take one thing, it's going to take an accumulation of factors in the meantime to allow people to be tortured in this country when in the execution process, and it's pretty clear that they have been. I think that's a violation of human rights. We should, if we're going to have the death penalty, we should be doing it the fairest, most humane way we possibly can. And we've had the death penalty throughout the entire history of our country. And so I have no problem saying, let's come up with the method that's most humane. But number three is, I haven't seen any inkling, not one shred, of any evidence to suggest that what you propose, which is an absolutely valid concern, is ever going to happen. Why? Because executions are conducted by Department of Corrections officials in a very secretive setting by people who have absolutely no idea what they're doing. And the people who do have some idea what they're doing, such as medical personnel or anesthesiologists or MBAs who could organize a jail the proper way, can never get involved in this kind of system. They never would, and they can't. Doctors are, by their oath, individuals who can't get involved in the process. So it's a catch-22. The people who could come up with the most perfect process or the most humane process are the very people who are the least likely to ever set foot in a lethal injection chamber. So as long as that catch-22 exists, and there seems to be no inkling that it never will, that it's going to perpetuate, that this sort of perfect system is one only in theory. Indeed, my argument has been it's been more chaos since the United States Supreme Court has addressed this issue in the last 4 years, more egregious lethal injection executions than there ever have been.
Professor Denno, thank you for your presentation. And I suppose what you're saying right now would be a good transition to my question. I was wondering, after reading an article in which you were featured in, the article mentioned how the firing squad method is actually one of the most humane. And I suppose the reason why our country is against that is looking at culturally relevant norms. It seems more of a primitive type of method. My question to you, though, is if we are trying to figure out the most humane, would you think that going to something back like firing squad is a better solution, or this one chemical method of injection, is that a better solution? Which direction should we be going in? Not necessarily which direction are we going in? Thank you.
Well, there are two questions that you had. I mean, first of all, is that the direction we should be going in and the direction that we are going in? The direction we should be going in, absolutely firing squad. There have been 3 firing squad executions in the modern history of this country, the modern history of the death penalty, that being since 1976. All have gone off flawlessly. We have trained marksmen to do it. There are 5 people, so and 1 empty gun. So there's a feeling also that a diffusion of responsibility in an execution process that I think is important for the people who are involved in the process. They're all within 10 yards of the inmate, and it's been done with dignity. It's a method that is associated with the punishment as opposed to some sort of medical process. So I think it's just more an honest statement that we're actually executing people here, as opposed to a dishonest statement of that this is putting somebody to sleep, which we're not. So I think for all those reasons that it is the better process and the more humane one. But for the very reasons that you wonderfully articulated, is it's the one that will never go into that direction because it's associated with brutality and something very primitive. And so we want the face of medicine, but we're really executing with the face of torture. So I think, so that's the direction we should be going in. What direction are we going in? We seem to be going into the direction, even though there is this vast scramble, into the direction of a single drug method. But you know, this is not just about the drugs. That's not just the problem. The problem is who is doing this, the method of execution. Even if you have one drug, that's not going to ensure that it's going to be humane, because you may not ever be able to inject someone. In the Romel Broom case, of the person who has survived his execution, they couldn't even get the one drug into his arm. So you still continue to have problems on who's doing it, where are they doing, and the conditions in which they're doing it. So that is the direction they're going on, because they've reached the dead end. I mean, what else are you going to do? You can't get a sixth method of execution. That would expose the flaws all the more.
Hi. Thank you so much for your presentation. Since you already said it, firing squad, at least to me, it does seem to be a more brutal touch to the death penalty. But my question to you is, do you believe that if the states who do use lethal injection to put prisoners to death, do you believe that if they were required to perform to undergo some kind of protocol or training to ensure that the prisoner does not suffer during the lethal injections, would you say that that'd be more humane? And kind of as in a way that this would kind of be personally training executioners, do you believe that that's also a humane look at it?
Yeah, I mean, again, that's a really great question. Actually, many of these states do. You know, I've been involved in litigation in a number of states on this, and every state will say they do have a protocol, they do have training, they do have teams that they train. But you know as better than I, if you've been on a sports team or had any kind of teamwork in a class or something like that, some members pull more than others. Some people know more than others. So the nature of the training can be a pretty flawed process. So yes, I mean, in theory, having a team and training that team and et cetera sounds good, and it may heighten the likelihood of the process being better. But in reality, even though states have training or have a team, when you start looking more intensely on how that training is conducted, it's conducted poorly. So if you're going to have a team, you should do it correctly. Part of the problem also is who is on your team. If it's people who aren't showing up, and I can't name specific examples because they've been under seal, or if it's people who really don't care, or unfortunately, people who may be sadistic or whatever, then even though you have that kind of effort, it still may not work, and it's certainly been shown not to work.
I'll join the chorus and say that I enjoyed your presentation very much. It seems to me, both by your presentation and questions and discussion in the room, that really much hinges on this question of what is humane. And my question then is whether the court has taken up the question, the attempt to define what humane is, establish criteria or standards against which any particular case might be measured against. And if so, what indeed those the criteria are.
Yeah, no, I mean, again, a great question. I mean, the United States Supreme Court has always said that death in itself is never going to be painless. So when we're thinking about the Eighth Amendment cruel and unusual punishment clause, it's not going to include a statement that a death must be painless. So, you know, death by virtue of what it is going to entail some kind of pain. So that's sort of the rock bottom standard, that we do recognize that there's going to be some pain involved. So then what's the next question? That it not be a torturous death is one of the standards, that there not be a risk of torturous pain. So it's not only that it might cause pain, but it might cause a risk of pain. The United States Supreme Court has also had standards saying that there shouldn't be a pattern going on. So that, you know, one of my arguments is that there's been a pattern going on for decades showing that lethal injection is unconstitutional because you have botch after botch after botch. But, you know, the United States Supreme Court has recognized, for example, that just one accident is not going to be a problem, that you have to have multiple episodes of accidents. So when you take this all together, what you get is sort of an Eighth Amendment standard that talks about length of pain, the torturous amount of pain, whether there's going to be a risk of torturous pain, and whether or not there's a pattern of pain. So when you're coming up with information or trying to pull all this together, which I have done, or tried to do anyway, is that those are the standards that I'm looking for to try to suggest that this is a constitutional violation.
You talked about the different methods of execution. What you just said, like the most painless and the quickest and all that. Wouldn't the guillotine fall under that?
I'm sorry, I didn't hear the last part.
Wouldn't the guillotine fall under that? Those protocols.
I'm sorry. What do?
The guillotine.
Oh, the guillotine. Oh, yeah. Well, several things. I mean, guillotine's been brought up, and first of all, we did have the guillotine, if you can imagine. It was never used in this country, but the state of Utah, at least historically, required that there be some showing of blood in an execution for penitence reasons. So this is how they came up with the firing squad. But the guillotine was never used in this country for several reasons. Number one, in response to the prior questioner's indication or query about execution methods, one of the challenges also involves the issue of dignity, which I didn't expressly mention, but that executions should be dignified, and for virtue of the inmate. And it was always found that the guillotine was not dignified because, for obvious reasons, that it would involve bodily mutilation. Indeed, Justice Brennan said in an electrocution case that he was against electrocution for that reason, because it was so undignified that the inmate was mutilated at the end of the execution. So that's why it was never seriously considered. I did want to add, however, that people do think that guillotine is an instantaneous death, but Jack Kevorkian, in one of his books, actually has evidence to suggest that it's not so instantaneous as some would believe, and that the guillotine was originally replaced historically because there was some indication that there was suffering after someone had been beheaded, that they were still conscious and feeling pain. And I won't go into detail on that, but it's as grisly as it gets.
Thank you so much for your presentation. You're welcome. My question is this. Do you think there is, your work seems to look at the humane issue, do you think there is a stronger argument to be made if you come at the death penalty from a fallibility issue?
Oh, yeah.
Given the number, I would say, I referenced given the number of exonerees with DNA and whatnot, does your research, do you at all examine the fallibility issue, and do you think that might hold more weight versus the issue of whether it's humane?
Yeah, I think that's a great question. All these issues have been enormously, have worked together. I see it more as a snowball effect, and that the innocence issues, along with the fallibility issues, and the wonderful research that's been done showing the amount of error that exists in the death penalty process. I guess I should have said at the beginning, I worked for 7 years before I went to law school, with the New Jersey Public Defender's Office, doing research on, with the wonderful Public Defender's Office that you have here, so incredibly sophisticated, on looking at every homicide that had been given the death penalty after the reenactment of the death penalty in New Jersey in 1982. And much of our focus was on the fallibility issue and the county-by-county differences, and the likelihood that a black defendant being linked to a white victim was going to be the most likely to be executed, et cetera. So I think that's also incredibly important, and I think all these factors work together. But let me give you a special sort of self-serving plug, I suppose, self-serving, and that maybe why I stick with this as long as I have been, and as fervently as I have been with lethal injection, is and why I think it's different, or sort of makes its own contribution in addition to all the wonderful efforts by other death penalty attorneys. And this is the reason. Lethal injection now applies to every single execution method, every single execution in this country. There's no death penalty penalty attorney worth their salt now that wouldn't bring up a lethal injection claim. So that's not the case with innocence. It's just going to, it's highly effective and very important work, but it's just going to apply to a splinter of inmates in this country. So it's very specific to that particular group, as is the other kinds of challenges that come up, whether it be challenges, litigation, very important litigation claiming that inmates are mentally retarded, a huge disproportionate number are, or that the wonderful work done on juveniles that's been successful in making it so that no juvenile will ever be executed in this country again. So there are many issues that are floating about in addition to the fallibility issue, but even the fallibility issue does not apply to every death penalty case. It's certainly disproportionate. But courts are also willing to recognize that we have a lot of fallibility in the criminal justice system. It's just always the case. We have, courts, the United States Supreme Court has unfortunately recognized in McCleskey v. Kemp that we also have racism in the criminal justice system. And they acknowledge that in these wonderful statistics that David Baldus presented. So the reason I stick with lethal injection is it applies to every death penalty case in the country, number one. Number two, as opposed to some other kinds of cases, it relies on objective evidence. Even to prove racism, you have to prove that there was purposeful discrimination. It's an incredibly high hurdle, even though the statistics, you look at them and you can say, how is there not racism here? But with lethal injection, you can accumulate objective, medical, measurable evidence that I think is really hard to rebut.
I know you said that typically a lethal injection consists of three different drugs, and then you mentioned a single one.
Right.
Would you say one is more ethical, or does it not really make a difference because it's the same end result?
Yeah, I mean, again, that's a great question. I mean, I think the single drug is more ethical, and I think, anesthesiologists who testify in this area would say that because you don't have the paralytic. The paralytic was also always originally the most egregious drug because if the single drug, if it's not putting somebody to sleep, then they can wake up and, allegedly tell someone that they're suffering or that they haven't had enough of the drug. So I think it's been a big step forward just getting rid of the paralytic. That said, if we're now relying on drugs, even for that single drug, that are purchased in different countries, that don't have the same kinds of filters that we do, that they're not being injected properly, or they're injected in the tissue rather than the artery or vein, et cetera. And if they're still being applied by incompetent executioners, then I think it can be a little bit of a red herring where people say, well, now lethal injection is okay, when it's still not okay. It's just one of many, many problems has been momentarily resolved. Yeah.
Hi. I have two questions. The first question is, what do you think of sort of the idea behind the death penalty itself regarding the prisoners, that, these are people who can't re-enter society and life in prison isn't sufficient alternative? And second, what do you think of the, you mentioned the benefits of the firing squad being the diffusion of responsibility. Do you think that can be put into other methods and that would be a benefit to other methods as well? Thank you.
Okay, thanks. Thanks for your question. I'm really glad that you brought up the life in prison issue. But you ended your sentence by, I guess your assumption was that that's not going to resolve things. Is that right? I do think it's a resolution. I think for many of these people that life imprisonment is worse than execution for some of these inmates, and that, for example, with the horrible home invasion offense in Connecticut, for example, that one of those inmates doesn't want life in prison. They want to be executed. A substantial portion of inmates volunteer to be executions. You have these volunteer executioners, in which case how they do that is they say they don't want any more litigation on their behalf. They simply want to be executed. When we as a society, if we really want to punish these people, want them to have life in prison. For a substantial number of inmates, that would be worse off. Secondly, life in prison, I mean, some of the problems that were associated with that originally are no longer existing. In other words, life in prison really means life in prison. It doesn't mean you're going to get out in 20 years. It means you're going to be in prison for the rest of your life, without the possibility of parole. And so all our concerns or fears about people getting out, or our concerns about retribution, about people getting out when they shouldn't get out, are I think, satisfied with life in prison without parole. So secondly, I do think the firing squad is the better course, that if we're going to have a method of execution in this country, that firing squad is more humane and it's more honest. You know, for the pro-death penalty people, hey, let's make it honest. You know, you want to kill somebody, let's kill them, you know, the American way, so to speak. Okay.
Thank you again for your presentation. I'm just curious, you know, over the course of really the history of America, we've seen a lot of situations where there have been, you know, systematic societal and institutional improvements as far as humane treatments of people in all situations. I think mostly of like mental health reforms and those kinds of things. So I find it shocking, I'm sure a lot of us do find it shocking, that this question has been allowed to kind of linger on for so long, and that we are now in 2012 and still seeing these terribly problematic methods being used. What do you think are kind of the underlying causes for why we have allowed that to go on? Do you feel it's, you know, due to the controversy of the issue, or perhaps because the people being affected by it are what we consider in some ways to be kind of the lower end of society because they are prisoners? What are your thoughts on that?
Yeah, I mean, I think you mentioned some of my thoughts on that, so thanks very much. I think several things are going on. We're a country that's very ambivalent about the death penalty. On the one hand, we want it, and we always voted in, and the state of California still voted it in, even though it came very close. On the other hand, we execute so few people every year. You know, it's really just the splinter of people who commit homicides, and we don't always execute the worst of the worst. So when we do execute, we always don't do it. We don't seem to do a very good job about it because we are sort of ambivalent. So we have it. We don't want to get too involved in it, and we don't have a very good way of doing it. Number one. Number two, I think your point about the fact that the people who are subject to the death penalty are people that do fulfill the lowest rungs of society. That I do think there is a racist aspect to the death penalty, particularly with all these statistics indicating that low or bias against the lower classes, et cetera, that's an issue. And number three, I think, particularly with the methods of execution issue, is that we just perpetuate the death penalty in any way that we can, even when it's in a flawed form. And we don't try to perfect it as much as we should have, because once you try to perfect it, and this goes to your question about lethal injection, once you try to start looking for better methods, you start exposing the flaws, because then people realize how bad it was before, and once that information gets out, then people really start questioning the death penalty entirely. So it just ends up being a big catch-22 where you don't want to lift this can of worms, because when you start seeing what's in there, it's pretty ugly, and you just put the lid back.
I'm going to kind of change topics just a little bit.
Okay.
You mentioned Dr. Kevorkian. There's a couple of states that have put forward legislation to put end of life, right to die, and patient-assisted suicide. How do we get things right on that side? You talked about perfecting suicide or perfecting the lethal injection. I can't imagine America putting up with the right to die if it isn't perfected. So how do we get it right on one side and not right on?
Yeah, I mean that's a great question. I mean, do it the way Netherlands does it. I mean, I don't see the right to die issue being the same kind of thing, although they're certainly parallel. And I've looked into the, what Netherlands does. I actually, interviewed at length the doctor in the Netherlands who created the assisted suicide system there. And there's several differences. Of course, number one, we're not dealing with a group of inmates who have been convicted convicted and given the death penalty in this country, you are dealing with normal individuals who are ill and want to die. And so that lifts the lid of secrecy over how we're going to end up doing this process. It's a very visible process. You know, I can tell you right now on how Oregon, what drugs the state of Oregon uses and how they dispense those drugs, et cetera, and how it's done there. And it's certainly very open in the Netherlands. I have the pamphlet that they use. You can get a hold of that. It's been translated, and the doctor there will tell you exactly. They will specify exactly what drugs are used and the measurement. You have it done by my medical doctor in the Netherlands, or you can have it done at home, et cetera. So it's a very visible, very medically with a lot of medical oversight in the Netherlands, in the same way that it is in Oregon as well. So with all this medical oversight, and that you would have somebody with you, actually you would have a doctor administering the drugs, et cetera, in a safe facility with the best care possible, that you could imagine that would not be problematic. We haven't had that many assisted suicides in this country, but the ones that we have had, you don't read about torture or something horrible happen. In the Netherlands, the worst thing that can happen is, because you're just using this one drug, the sodium thiopental, is sometimes it can take a long time for someone to die. But they've worked, several hours. Because you don't have these other drugs that we've been using in our executions. But nonetheless, the Netherlands is working on that with efforts to make the person die quicker for the benefit of the family.
You mentioned that the firing squad is your choice and that we would probably never go back to it because it's so brutal, but don't you find that rather ironic in a society that's built on guns?
Yeah, I find it tremendously ironic. I think, I think this is a process nobody wants to get involved with, right? Doctors don't want to get involved with the death penalty, but also gun-toting gun owners don't want to get involved with the death penalty. You know, they have enough, I guess, of a reputation to protect. They want guns to be used because of the Second Amendment, the right to bear arms and to hunt and to protect themselves and defend their families and to defend themselves from harm. So they don't want to be associated with a process where you're using guns to actually execute people, or many of these people don't. But I find it tremendously ironic. I think if you had an opinion poll and asked most people in this country would they rather have the firing squad as opposed to lethal injection, I'd be interested to hear the results of something like that, to see which people would prefer, particularly if they knew that firing squad was more humane. Even though it has the more brutal reputation, of course, I'm for it because in actuality, it's the most humane.
Do you think that if it ever came to that point, that it would be blocked by the NRA? We would have trouble with that?
Oh, absolutely. I think that there would be an enormous amount of litigation on the part of the NRA or lawsuits, et cetera. I mean, look what's happened with lethal injection. I mean, you have two companies so far making these drugs, Hospira, the creator of sodium thiopental, and Lundbeck, the creator of pentobarbital, the drug that states were starting to choose from, both getting out of the business, basically. Lundbeck now has a contract that prisons have to sign saying that they will not use this drug for their execution procedures. So absolutely, you can see gun manufacturers not wanting their brand of gun to be used in this because, of course, attorneys defending inmates or making sure that these firing squads are humane would absolutely want to know what guns are being used. So it's a never-ending story of irony.
That's the end of our presentation, so thank you so much again.
Thank you. Thanks very much for your great questions.